Can you just screw up a parking charge notice, put it in the bin and ignore it? Well, the short answer, with a huge caveat, is yes, sometimes. It's not always advisable, which is why I'm making this video. There are certain very narrow situations that this might actually be a good idea. Not that this is legal advice, of course it's not. But I see many videos going around to say that this is exactly what you should do, and some people, I fear, will take that as blanket advice to throw any yellow ticket on the vehicle in the bin, which is not a good idea. And for my regular polite interruption, if I could ask you all to join me on my new channel, Daniel Shensmith, linked in the description below, where I'm helping you to build wealth. There's also going to be a giveaway across all three channels, so stay tuned for that one. A giveaway for each channel, so it's going to be something decided for Black Belt Barrister, something for Black Belt Secrets, and something for my new money channel, Daniel Shensmith. So it's going to help you make money, that third giveaway. One lucky person for each channel. I'm going to announce what they are very soon. But if you want my personal thoughts on things as well, check out Black Belt Secrets, linked in the description below as well. I am so grateful to almost be reaching 100,000 subscribers there. That in itself is another huge milestone. I'm so grateful to all. Back to the video. Because sometimes there'll be a penalty charge notice, which are a little bit more serious than the parking charge notice variety, because the penalty is an official one and the parking charge notice is issued by a private company. Now, you'll deal with those in slightly different ways, but talking about the parking charge notice, which is the private kind. Now, can you throw those in the bin? As I said, sometimes yes. The important bit that matters is really twofold. First of all, whether the company is a member of an accredited trade association. Now, you can look this up and usually find out from the British Parking Association or the International Parking Community to see whether this parking company, which will be at the bottom of this ticket, presumably, is a member of an accredited trade association. Now, if not, this is the important bit, if they are not a member of an accredited trade association, then the DVLA, according to their own guidance, and I quote, will not disclose data to parking or trespass companies who are not members of an ATA. We expect the ATAs to monitor adherence to the code of practice and investigate and address non-compliance when it arises. So what does that mean? Well, the company can't get your details to write to you to ultimately sue you for the breach of parking, as alleged, because we don't accept it unless it's either admitted or adjudicated and determined by a court. At least that's the way that I see it. So if they are not a member of an ATA, they cannot get your details from the DVLA, and therefore they cannot write to you, they cannot sue you, and so on. Now, there's one or two subtle caveats that might weave into this. For example, you check, they're not a member, you throw it away, they become a member, they get your details, then they try and sue you. But then the time frames might come into play and the fairness might come into play, which sort of brings me on to the second part of this explanation here. That being, you might have heard of the Protection of Freedoms Act of 2012. Now, these parking charge notices may or may not reference the Protection of Freedoms Act. If it does, it's sort of a double-edged sword. On the one hand, it may, given certain criteria, make the registered keeper or the hirer of the vehicle liable to any of those parking charge notices that arise. As I say, there's lots of conditions, but we'll come on to those in another video. It may make the registered keeper or the hirer liable for those. But in referencing the Protection of Freedoms Act, certain timelines also come into play and notices come into play. So first of all, there may or may not be a notice to you at the time that you've parked the vehicle. And then if you don't get a notice at the time that you've parked the vehicle, you must receive one within 14 days. If you did get a notice at the time that you parked and you reply to that notice, then they don't have to send you another notice. But if you ignore that notice and you don't reply to it, then they must send you another one within 56 days. This, all of which to allow them some firmer remit, potentially, against the registered keeper of the vehicle or the hirer of the vehicle. Now, if the notice doesn't reference the Protection of Freedoms Act, there is no time limit for them to chase you and serve you with a notice they're going to sue you for the money if you don't pay it and so on. However, that being the case, if some notice is delivered to you many, many months after the event, you can then argue that it's unfair, although that will ultimately fall to be determined by a court. And there's obviously lots of different ways of arguing whether that's fair or not. And then, of course, after all those considerations, we come to talk about the standard arguments as to were you parked correctly, were the signs clear, were the markings clear, was there an appropriate way to pay, was the machine working, was it a cash machine but not accepting the coins, for example, were you overcharged, if you potentially you weren't the one driving when the ticket was issued, and there's an argument about all of that. Some other emergency reason you couldn't get back to your car, so that might make it unfair to penalise you for that. If, for example, your car might have broken down so you couldn't remove it, all those sorts of things. All sorts of different arguments, and many of which have been successful in court against these parking charge notices when they've been argued that they've just been unfair. Many different cases have argued that these have been unfair, and so the court has not upheld the ticket. But winding back to the beginning, making a bold assumption, as many people do, watch the comment section, jump up and down here, because many people do say in the comment section, just ignore them, throw them all in the bin, they've got a collection of them, they've never paid them, and so on. Well, if you look down the court lists, and you can do this yourself because this is publicly available at a website called courtserve.net, you can look up court listings up and down the country. Many of them called the Daily Cause, just provides you a list of different cases that are going on. If they are family cases, they'll be anonymized as initials and so on. But many of the others will just be company name against individual name, company name. And when you see XYZ Parking Limited, that's not a proper name, by the way, that's just an example name, a parking company management, whatever, limited against, Mr. and Mrs. Bloggs, as an individual, those will be parking companies taking these individuals to court for non-payment of a parking charge notice because they ignored it. Now, that will only happen when they've got their details, and so unraveling this situation, they will have had to get their details to threaten to sue them for non-payment of the parking charge in the first place, and then obviously take them to court for it because they haven't paid it. So if they haven't paid it and they end up in court, they will have to provide some kind of argument, some kind of reason as to why the ticket wasn't fair. Now, if it wasn't fair, in many cases, you might remember, if I remember, I'll link the video in the description below, where I sent a firm but polite letter to a parking company that gave me a ticket where I did have a permit to be parked where I was parked. They wrote back, perfectly fair enough, and said, we accept, they didn't accept it was wrong. They just said, on this occasion, we will cancel it. So they cancelled the parking charge notice in my case because I wrote a fairly firm but fairly polite letter to them. But because I outlined the reasons why I didn't think it was validly issued, I didn't think it was fair, because the enforcement officer should have, not an official enforcement officer, you understand, a parking enforcement officer privately employed by the company, should have been able to see the permit through the window and didn't. But if they would just turn their head a little bit, they would have seen it. Now, in my view, a court would have said in under 5 minutes. It's what I call a 5-minute case. Quite interesting, actually. Many of these cases were in and out of court in 5 minutes flat, sometimes because what a defendant provides is not a defence. So sometimes there might be, we're going off track here, but this is just for your interest and information. We'll get a case sometimes where a defendant will come to court over a contract where they've paid a certain amount and then stopped paying and then say, this is not fair, I don't agree with the charges, or I don't agree with the interest, or I don't agree with this, or whatever else. Sometimes in their defence, they will start out denying that there's a contract in existence, and then partway through they'll say, well, actually, I've paid most of this anyway, but the last bit I think is unfair. But having paid a certain amount towards it and acknowledging that those payments were right, but then the last bit was unfair, that's ultimately an admission that the contract was valid in the first place. So there is no defense against the contract, essentially. And then, therefore, the court is within 5 minutes going to say, well, there is no real defense against this contract, so we're going to rule in the claimant's favour. And in other cases, there might be an excuse as to why payment hasn't been made on time, but not refuting the existence or the validity of the contract in the first place, which is one of the mistakes a lot of people do on these parking charge notices. They don't attack the validity of the parking and the charge and the notice and the terms or the fairness of the terms and things like this. One of the mistakes people make is just say, this is unfair, but without saying why it's unfair. They might say, it's outrageous that I'm being charged £85 just because I was 10 minutes late, which on the surface, to many people, might sound that it's unfair, but in law, it's not. The Supreme Court's been quite clear that that's not an unfair term. But if there is a reason that it could be made to be unfair in the circumstances, because the Supreme Court case in Beavis and Parking I is not, whilst it is the definitive word that it is not a penalty, and that charge by itself is not unfair. In that case, on those facts, there may be another situation where it could be unfair. For example, if there's one sign and it's way over on the other side of the car park with tiny writing, and unless you walk, a third of a mile to see the sign on the other side, and it's even then it's tiny writing in the dark, it's not illuminated and whatever, that would be unfair, potentially. Most likely, because it's on the other side of the car park. So you need to put these things into context. You need to pull all the details together. If you're going to say it's unfair, you need to say why it's unfair, not just it is unfair, therefore I shouldn't pay it. So winding up, yes, in some situations, you'd probably be safe to throw these things in the bin. But, and sometimes it might be better to do that, because if they can't write to you, then obviously they can't chase you for the money. This is not that I approve of, overstaying and taking advantage of these parking companies and things like that, because you know that they can't chase you. Obviously, I don't think that's fair. I'm not an advocate of doing things unfairly to other companies. They do have to keep the revenue going and keep the upkeep of the building and so on. So I'm not advocating that. But if you genuinely think it's unfair and you check and they're not a member of an ATA and there's no way they could find your details from the DVLA, you could take that risk at the very least. And ultimately, if they do somehow get your details, they do write to you and then they do threaten to take you to court and you do feel that, well, it's kind of justified, then you might be better off paying it. But if you still think it's unfair, go through that list, the very brief list that I've given you, the briefest of overviews in this video as to why that might be unfair, and then you could potentially challenge it. I hope that's useful. If it is, please do bop that like button, share this video with somebody. YouTube loves it when you share these videos with people, so please do that. I'm so grateful to you all for passing 350,000 subscribers here, and don't forget to check out my other channel, Daniel Shansmith, in the description below, which has now gone past 10,000 subscribers. And for my personal views on a great many matters, join me on Black Belt Secrets, which is just approaching 100,000. Thank you all so much. I'll see you next time.